Okay, welcome everyone. And this is a start of a new series of medical legal talks for education and brought to you by Dr. Shield, who will be kindly organizing one talk a month for the next 12 months at least. And to kick it off, we'll have the first one, which is a talk on aggravated and exemplary damages, the relevance to medical negligence claims. And the speaker is Ms. Shamini Navaratnam from Siva Dharma and Associates. So I'll be streaming the pre-recorded talk, and Ms. Shamini will join in at the end to answer any questions. Okay. Now, this talk is eligible for CBD points. I just want to take a moment to show you how the points are claimed. And during this live stream, which will be for about 40 minutes, followed by Q&A, and after that, we'll display a QR code. So this QR code, you can scan it with the MMA app, and you'll automatically get the point. Now, the code is only valid for about an hour plus. So the video will still continue to be hosted. And and on our page, which is dops.my.medicolegal-CME, and some of you may be viewing the talk in this page, you see there will be a link to the CME module. If you're a registered DOPS member, even though the live stream has ended, you can take MCQs in the CME module and still get the point if you get all the MCQs correct. Okay, so that's the offline way of getting the CME if you're not watching it live. All right, so I want you all also to know that we'll be taking comments, questions, and answers using YouTube live chat. Now, the issue with this is you need to be viewing the video on YouTube itself. So if you are watching it on the dops.my page, and let me show you again, if you hover your mouse or if you tap on the top part of the video screen, you'll be taken direct to YouTube app or the YouTube web link, then depending on what device you're watching this on, and you'll be able to see the live comments or chats which you can enter your questions subsequently. Okay, so later on when we do the Q&A, I'd like you to hop over to the YouTube app or the YouTube link, and then we'll take your questions there. All right, and before I proceed, I'd just like you all to make a little request that could you please subscribe to our channel, because by subscribing and then enabling the notifications for our next live streams, we'll have more than one from DOPS every month. So in fact, this Saturday, there's another CME live stream. So if you are subscribed to our channel, you'll be notified by YouTube of our upcoming live streams, okay? And then I will be displaying the QR code in this blank space at the end of the session. Right. Before I proceed, while waiting for more people to come online, so since this is a Dr. Shield organized event, I'll just like to play a little video from Dr. Shield. Okay.
We're Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Okay, so thank you, Dr. Shield, for organizing this medical legal series. So without wasting too much time, I will now share Ms. Shamini's talk. Okay, can you all see this? Okay, I'm going to remove myself from the screen and I'll start the lecture.
Everyone. Today I'm here to speak to you about something I think that a lot of us have heard a lot about, but maybe we have a little bit of confusion. There's been a lot of this in the media, in the social media and print media. A lot of people are talking about this. So I'm here today to explain to you a little bit about aggravated and exemplary damages. Before I even go into aggravated and exemplary damages, as many of you are not lawyers, perhaps I'd like to explain to you what is the concept of damages. Today, this talk will be limited to damages in relation to tort, and tort in particular, I will be emphasizing on medical malpractice, which is, I think, the area which everyone who is going to listen to this talk is interested about. All right. Before we go into the different types of damages, perhaps we need to know how it arises. Damages only arise if there is a party. In medical malpractice, of course, it would be the patient or patient's family or next of kin who are unhappy in relation to some adverse outcome to treatment being given to the patient. As you all know, in medical malpractice, there are three main areas in which malpractice can arise. One of them is failure to advise. The second one is failure to diagnose. And the third one is, of course, treatment, failure to treat. Or not really failure, but this would be if these are the three different areas in which malpractice claims can arise against medical practitioners and or hospitals or clinics. These are the three main areas in which a patient or patient's family can bring a claim against doctors, nurses, hospitals, medical professionals. All right. So assuming an adverse event has taken place, someone has gone for surgery and there hasn't been the outcome they expect, or worse still, someone has passed away after surgery or treatment, the next thing they will think of doing is, of course, to bring a claim. So as all of you know, or may not know, the first thing they will do, which I'm not going to touch in this talk, is the fact that they will apply to the relevant hospital or clinic or doctor, first for the medical report, and then they will ask for patient's records. All right? They do this in law now. They can even if they don't know if there has been any form of negligence or malpractice, if they suspect something is amiss, they can actually go to court for something known as pre-action discovery. All that means is that they are going to court, telling the court that I went for treatment, and after the treatment something has happened. I believe something is wrong. I need these documents because I need to take it to an expert. The expert needs to review the documents, and I intend to bring a claim against doctors or hospitals or whatever other person has administered treatment. And this has been happening very often now. I think patients and lawyers are very well aware of this procedure, and they're using it to their great advantage. And under discovery, the discovery has become very wide, not just to get access to patients' notes as defined under the Private Healthcare Facilities and Services Act or under the MMC guidelines, but now the court has actually stated, has decided case law to say that patients can actually be entitled to the internal inquiry report, or in some cases even the incident reports. So as you can see, that this would mean that patients have access to a lot of information. So once they have this information, what the patients do then is patients or their solicitors will engage an expert. And what the expert will do, of course, is to study these documents in detail. And as you would appreciate, in retrospect, it's always easier for them to find some kind of mistakes in any one of these areas, which is advice, diagnosis, or treatment. In the recent cases that I've been handling, the emphasis has been actually in respect of failure to advise. What the lawyers are doing is that they are trying to persuade the court that patient autonomy is very important, and therefore in any kind of procedure which the patient is going to undergo, surgical or otherwise, the patient needs to know what procedure is going to be undertaken, and they have to be given informed consent, and they have to be given a choice on whether they want to undergo surgical treatment or whether they want to undergo conservative treatment. I think previously there hasn't been very much emphasis at the beginning stage for so much of involvement with the patient. But I think now it is becoming very important that we engage with the patient, right? So, okay, that's just a small comment that I'm making. But to go on to the fact of when does the claim arise, once the expert has all the records with him, he will advise the patient or their solicitors that there has been some element of either omission or commission which gives rise to a claim. And this is when the claims are filed. In a claim for tort, all that they need to prove is that they need to prove that there is a relationship between the parties which gives rise to something known as a duty of care. Of course, with a doctor and a patient, this will always arise. With a hospital and a patient as well, it always arises. And so with any other healthcare professional. So that, I think, is a given. All right. So once they can prove there is a duty of care, the next thing they will say is there has been some act or omission of a system failure, which has resulted in a breach of that duty of care. Once they can say that the relevant parties are there, there's a duty of care, there's a breach. The third part is what we are going to talk about today. And that is, we are going to talk about the fact that they then can make a claim against what is called a tortfeasor. The tortfeasor would be the person who has breached the duty of care, which is usually in medical malpractice cases, doctors and hospitals. All right. So hospitals, of course, is due to system failure Or now under the law, there is a concept known as vicarious liability. If you're employed by the hospital, then they will take responsibility as you are the doctors are their employees, or the broader concept of non-delegable duty, which is a concept which states that since the patient has come to your hospital, they expect that all the doctors will conduct themselves in a manner which is not negligent, and it is not for them to be involved on whether or not the doctor is an independent contractor or not. All right, so that is the way the liability can attach to a hospital clinic. All right. Okay, so the third thing I wanted to talk about is what is the relief that they're going to claim. What I'm going to talk about today is in relation to the relief that any victim of a tort can claim against a tortfeasor. All right. So this is where the general idea of relief for a patient is, of course, they want the money, right? So in law, what do we call the money? That compensation that the patient is entitled to is given a broad heading known as damages, all right? And damages are divided into two main parts. One is called general damages and one is called special damages. General damages relates to the injury that the patient has suffered and the permanent residual disabilities that the patient has. All right, so in law, for each injury, the law deems that the patient has undergone what we call pain and suffering. And for that pain and suffering, for each type of injury or for many types of injury, in fact, as far as the courts are concerned, they have actually created a compendium which gives the general range of damages for various common types of injuries to different parts of the body. But at the moment, the courts are not relying purely on the compendium, but what they are doing is they are actually relying on case law. In Malaysia, we follow the common law system, which means we follow precedent. Precedent means previous decided cases. So the courts are usually guided when they want to award damages. They are guided first by the compendium, secondly by other decided cases to award the patient's compensation. As I said, the first kind of compensation that patients are entitled to would be what is called general damages. All right, general damages relates to the pain and suffering and permanent residual injuries. And this again is usually proved by expert medical evidence. What is the initial injury suffered by the patient? And then after a year or two, they go and see a specialist, and the specialist comments on the permanent residual disabilities. And based on that, they are given what is known as general damages. Apart from general damages, they're also entitled to claim special damages. What are special damages? Special damages are
Hi, sorry for the temporary interruption. My Wi-Fi has just died, so we are trying to reset the Wi-Fi and give us 1 or 2 minutes, and I'll continue for where we left off. Okay, my thousand apologies. Okay, so the video will come on in a little while once the internet is back. Okay, so apologies once again. Stand by, please. This is a problem where with Unify, so the Unify suddenly cut off when we were streaming halfway. This seldom happens. So, okay, still can't connect yet. All right, coming back online. So again, apologies. Right. Okay, sorry. Thousand apologies. And let's see. Right, I'll have to share the screen again. Huh? Mm. All right, so we are back, and I'll be resuming for where we were. So apologies, and here we go.
Entitled to interest and costs of their action. Until very recently, this was the only heads of damages that a patient could claim against a doctor or a hospital. But times have moved on, and that is what I'm going to talk to you about today. That was just an introduction. And today, what I want to say is that the courts have gone on to say that patients are not just entitled to these general damages for pain and suffering and loss of amenities and special damages, but there's another head of general damages which they may be entitled to, which is either in fact, there are two separate heads. One is called aggravated damages, and one is called exemplary damages. All right. And this is what I'm going to talk about today: aggravated and exemplary damages. All right. So the next thing I wanted to tell you, this is a technical point, so I'm not going to spend too long about it, is the fact that in order, if a patient wants to claim for what is called aggravated or exemplary damages, the federal court has now stated that this item must be specifically pleaded. So specifically pleaded means in the document which is filed in court for the claim against the doctor or the hospital, there must be a statement in that statement of claim to say the patient is intending to claim for aggravated or exemplary damages. All right? And these are the cases. It was not very clear because previously people said you did not need to plead it in the statement of claim. The court was still had the discretion to award you aggravated damages. But that is not the case now, because in the recent cases, they have stated that it needs to be pleaded. This is the case of Tenaga National and Evergrowth Aquaculture, which is not a claim of medical malpractice. It was another claim by Tenaga National against a customer. But this principle applies to all areas of the law. So now it must be pleaded. The other case that I wanted to talk about in North Fazana Ida binti Faisal. This is a malpractice claim, a claim by the mother and father of a child who was born with with cerebral palsy, was quadriplegic, and they claimed for what was called ganti rugi tambahan. So in the Court of Appeal, what happened is the Court of Appeal said is there's no such terminology as ganti rugi tambahan. They said, the lawyers argued that ganti rugi tambahan could mean or does mean aggravated damages. In the Court of Appeal, the Court of Appeal disagreed with the patient's lawyers, and they said that no, aggravated damages, the proper term is ganti rugi teladan or ganti rugi tero. Since that was not pleaded and they put ganti rugi tambahan, it was stated that the Court of Appeal said that the parents could not claim for the $500,000 they were claiming as exemplary damages. In fact, this case, they actually claimed for 500,000 aggravated damages, and they claimed for 500,000 punitive damages. All right. So the Court of Appeal didn't allow it. But what happened was that the lawyers took this matter up to the federal court. And in the federal court stated that no, the lawyer was correct. A term of ganti rugi tambahan could be used to entitle them to claim for for aggravated damages. And therefore, the appeal was allowed in the federal court, and they managed to get their claim for aggravated damages reinstated. All right, this is a claim where liability was conceded. It was against the government of Malaysia. Liability was conceded. When it went for assessment for damages, this is when this issue arose. All right. So I think this may be a good time for me to explain perhaps what's the difference between aggravated damages and punitive damages. Aggravated damages is usually due to some conduct by the tortfeasor which has caused more distress to the victim of the tort. All right. In this case, then what is known, the court decides that in certain circumstances, which we will examine later, the court is entitled to award the patient or the family a head of damages known as aggravated damages. Punitive damages is, as the name suggests, is something where the court feels the conduct has been so atrocious that they want to make an example so that this kind of conduct will not be repeated again. It is something which should act as a deterrent, all right, to prevent such actions from being repeated, and therefore they give what is known as punitive damages. All right, so there is a difference between aggravated damages, which is usually just the conduct of the tortfeasors, which gives rise to this head of damage, as opposed to some kind of conduct where the court feels is totally unacceptable, and an example must be made so that it's not repeated, and therefore they are awarding what is known as punitive damages. All right, I will go very quickly on the historical background. As I told you, before 2018, no one, or rather the courts in Malaysia, never awarded what is called aggravated damages, all right? And the first case, which I am not going to speak about in detail because I've dealt with it before, and I'm sure all of you are familiar with, is the Dr. Hari Krishnan case, which was decided in the federal court. So this is a case where, because of various factors, very specific factors, which were mentioned in the judgment, the federal court decided it was appropriate. They said Malaysian courts have the power to award what is known as aggravated damages. And in that case, a sum of $1 million was awarded as aggravated damages. I think this is the highest amount so far that I know has been awarded for aggravated damages. This case in 2018. All right. And of course, shortly after that case was the case of the Datuk Stanley Isaacs case against the government of Malaysia. All right. This was a case, I think there was a delay in treatment of the patient. And in that case as well, the courts found it appropriate to award the sum of 500,000 as aggravated damages. This, I'm not going to deal with it in detail because, as I said, these are cases which I'm sure everyone is familiar with, and I've spoken about it earlier. All right, the trend of aggravated damages has continued. And in this case of Nur Sharafina, is a case where the government of Malaysia again conceded liability. But it was very strange in that case just because they did not disclose the internal inquiry report until after they filed the defense. The conduct of the defendants in not releasing the internal inquiry report in the court's view amounted to a circumstance which entitled the plaintiff for aggravated damages of $200,000 being awarded. Okay, now I'm going to tell you about what has happened from that date. This trend of aggravated damages has been continuing, is being built upon, right? It is gaining traction. And let's see how the courts have dealt with it. All right, this is a case I don't know if many of you read about it, but this is a case which I think among the legal fraternity, we were quite surprised when this case was reported because normally for cases of medical negligence or medical malpractice, as I said in my introduction, it was only pain and suffering. And in very rare cases was aggravated damages awarded, all right? And especially for, in this case, it was a circumcision which went wrong, all right? So in the normal scheme of things, the damages which would be awarded for pain and suffering would not be a very large amount, all right, according to previous case law. But when this case came up in the High Court, what happened was, I think this, the facts of the case was this boy went to the Kuala Lumpur hospital, and what happened was the hospital assistant carried out the circumcision. Something went wrong. And then he referred the boy back to the hospital. And when he referred the boy back to the hospital, there was a delay in the Kuala Lumpur hospital getting an ambulance to transport the boy. They couldn't do anything. They couldn't fix it there. So they had to transport the boy to Selayang Hospital for whatever corrective surgery to be done. And what happened when they went to Selayang Hospital is, again, there was a delay. All right, there was a delay. I think he could only be attended to much later. And those are the facts of the case. So there was a delay once in getting the ambulance and sending him to Selayang Hospital. And the second delay was the delay in Selayang Hospital itself to attend to this boy. All right, so what happened there? The judge was very upset, was very, very upset in the conduct of both the Kuala Lumpur Hospital and the Slang Hospital. So what he did there, he awarded two heads of damages. He awarded 500,000 as aggravated damages, and he went in to award a further sum of 500,000 for punitive damages. So as I said, everyone was very surprised because the usual $1 million cases which have been decided is like the earlier one I spoke about. Most of the $1 million awards have usually been in brain damage cases, cerebral palsy at birth. These type of cases usually have been the ones which have attracted the $1 million awards. But here was a case of a botched circumcision, and the patient was awarded 500,000 as aggravated damages and 500,000 as punitive damages. I believe the matter has been appealed by the government of Malaysia, but at present I don't think the appeal has been heard. So this case is reported and it is the law now. So it is actually open. As I said, we need to be aware of this because if there is delay in attending to any, things will always go wrong, all right? In any hospital or any clinic or anything we do, things can go wrong. But what I think we have to be very aware of now is the court is not accepting the fact that we have a lack of resources, we don't have the staff, we couldn't open the theatre, we don't have enough ambulances. The court is not accepting all those as reasons that we did our best. They're not accepting this as reasons why they should not award aggravated and or punitive damages. All right, so it's good for us to see the fact scenarios so we will be aware of how this idea, you see in Hari Krishnan, the fact scenario was in relation to tampering of the records. The court, or what the court felt that the records were not accurate. There was some tampering of the medical records. It was, there were additions or deletions, and they felt that that kind of behavior was unacceptable. And in those circumstances, that was one of the reasons, I believe, which persuaded the court to award aggravated damages. And the other one we saw where they didn't release the internal inquiry report. Here we are seeing a case of delay in just attending to a complication which occurred, entitling the victim of the tort, the parents, or the boy actually, I think the victim was the boy, to be awarded a sum, 500,000 as aggravated damages and another 500,000 as punitive damages. These are the facts that I've set out here. A hospital assistant carried out a circumcision and attempted to stitch it back. The hospital assistant notified the hospital and advised the patient to go to hospital. The Kuala Lumpur Hospital delayed the transfer to Selayang Hospital. Selayang Hospital delayed the surgery despite being informed of the case earlier. There were further delays, causing the surgery to be conducted in the evening, 10 hours after the incident. The breach by the doctor in Selayang Hospital was the delay in conducting the surgery. So here you see the 22-year-old boy was awarded 108,000 as special damages, 2 million in general damages, 500,000 in aggravated damages, and 500,000 in exemplary damages. So you can see here, as I said, I do not know of any case before this which has given the sum of $2 million as general damages for pain and suffering and loss of immunities. This is a very, very high amount just for the injury suffered by this boy. All right. But over and above that, they've given aggravated and exemplary damages. All right. Let's look at another case. This is a case of Arjun Gopal Subramaniam versus the Subang Jaya Medical Center. All right. This case is a very recent case where the plaintiff was a boy, he was a student, all right, and he was awarded by the High Court. This is a claim, I think the first two defendants, the hospital and one of the doctors, had settled the case with the plaintiff. It purely proceeded against one of the doctors, the ophthalmologist, and this is the case against only the ophthalmologist, all right, which went on in the High Court. And in the High Court, the judge awarded 400,000 as aggravated damages, all right? And what is interesting is she talks about when can aggravated damages be awarded. And she cites the case of Sambaga Valia Ponasami versus Datuk Bandar Kuala Lumpur. And it's good guidance because it says aggravated damages is a species of compensatory damages which are awarded as additional compensation where there has been identifiable injury to the interest of the personality of the plaintiffs, where this injury has been caused or exacerbated by exceptional conduct of the defendant. Aggravated damages may be awarded in light of the motive of the plaintiff. All right. So, and then she also referred to the case of Muhammad Rizwan bin Abdul Razak, which was a case where aggravated damages can be awarded. This is the precedent which allows her to award aggravated damages. All right, let's go into the facts of this case. In the above case, the ophthalmologist was giving the patient steroids and vision was not improving, but did not stop the steroid immediately, as opposed to the evidence of other experts that they would have stopped the steroids immediately. All right, so this is a case where the ophthalmologist didn't tell the patient to stop using steroids, where other experts came to court to say they would have told the patient to stop steroids immediately. The court came to the finding there was no evidence that the patient was informed to stop taking the steroids after 1 month, and the patient was given 2 bottles by the pharmacy at the hospital. The court concluded that the cataract suffered by the plaintiff was steroid-induced and could have been avoided if the doctor had revisited her original diagnosis that the patient was not responding to steroid therapy. All right? This case is presently under appeal to the Court of Appeal. All right? So we will see whether the Court of Appeal agrees that these circumstances entitled the court to award aggravated damages. All right? But just as a side issue, this is another case where I think the grounds of judgment have released by the judge. And then she goes on in the grounds of judgment to say she should not have awarded aggravated damages because in the statement of claim, the plaintiff did not plead for aggravated damages. All right. So although she awarded it in the case, in the grounds of judgment, she said she was wrong to award it. So I don't know what the Court of Appeal is going to say. We will wait and see. All right. This is the latest case, which just came out on the 24th of March, just recently. All right. And this is a case by the same judge who decided the case of the botched circumcision. And the facts of the case is the baby died a day after birth and action was commenced by parents against the doctor and the hospitals. The defendants conceded liability. What are the facts of the case? The mother suffered distress after a water bag burst on November 16, 2016, while at the hospital. The doctor left it to the hospital nurses to deal with such distress and only visited the mother the next day. On examining the mother, the doctor directed an emergency operation. Upon delivery, the umbilical cord had strangled the child, resulting in death a day after the birth. All right, and what did the judge say? He awarded them 500,000 as exemplary damages, together with another 200,000 as damages for pain and suffering. All right. And what did the judge say here in the grounds of judgment? He said there was an inordinate delay on the part of the doctor who attended to the mother, which resulted in the complications the infant suffered, leading to death. The learned judge stated there was no plausible explanation for this delay apart from the nonchalant attitude of the doctor with regard to her duties. He went on to say he considered the doctor's attitude as leaning towards recklessness and criminal negligence. The learned judge was of the view, as a lesson to the medical professionals carrying out the duties, a clear message has to be conveyed that such an attitude cannot be tolerated, especially if it leads to death. There was no necessity to adduce evidence to prove pain and suffering, as the parents suffered depression upon death of their firstborn. The loss is difficult to quantify in monetary terms. There's no fixed formula to assess such a loss. So again, you will see how the judge has awarded aggravated damages. All right. In this circumstance, there was a delay in the doctor attending to the mother in a case of a mother in labor, and that has resulted in an award of aggravated damages being awarded to the parents of the baby which died. All right, now is the most important thing, I think, for us today as medical professionals, is how do we avoid aggravated damages being awarded? What are the steps we can take? All right, the first one, I'm giving you these steps based on the decided case law, all right? And these are, the categories are not closed. There may be other grounds in which aggravated damages may be awarded. And the first thing to avoid aggravated damages being awarded is there should be no tampering of medical records. Any additions or deletions must be clearly done with accepted practice as soon as possible. If retrospective entry, put time and date so that it's clear that it's a retrospective entry, and initial the same so that the identity of a person making the entry is clear. Second one is to provide all medical records upon request of patient. This, I think, is now being complied with. Probably doesn't apply to medical professionals, more relevant to hospitals and clinics. But I think the law is very clear now. You do have to give them everything upon request. All right, the third one is, of course, you must communicate with the family if complications arise, so that, and document the same, that you have not avoided them, or you have not decided to hide such an incident if it takes place. All right. Again, what about internal inquiry reports? You must be prepared to release it if the patient requested for it. All right. However, I understand that in certain circumstances, you may still decide not to release it. but the law is now very clear. I think you must be prepared to release it if it's requested to by the patient or their solicitors. All right. Assist with remedial treatment. This means as soon as a complication arises, do your best to make sure that any remedial treatment can be done as fast as possible. Here, I think I'm looking at the fact of that case where they didn't get the ambulance in time. There was a delay. There was a delay in transporting. There was delay in getting, it could be delay in getting the right specialist on board. So make sure that you assist and do not delay, all right? And if there is a delay which cannot be avoided, please document the reasons why the delay occurred, all right? And then the next one is, of course, to investigate. This is like in that case, when the patient complains, don't just leave it to the midwives or the nurses to just attend to the patient, thinking it's just normal delivery and all mothers go through labor, they can't tolerate pain. You can't assume that, all right? If you are the doctor in charge and it's your duty to attend to the patient as soon as possible. And again, I would like to say in hospitals, you must make sure that the patient gets into the correct ward. All right, if it's a labor ward, they must, if there's no space, you must make sure as soon as possible they're put into the labor ward, and all the relevant investigations, if they're on CTG tracing, the CTG must be on. All the recordings must be there. The pathogram must be filled in. All the documentation must be done properly. And the most important, of course, is for the doctors to come and review the patient. Because if the doctor comes to review, and most important, don't just review, you have to document what you review. If the nurse does an investigation, it must be documented. Because if you can show the court that you've investigated, you've done your best, and even though you've done your best, you have noted the complication and you've acted on it, it'll be very, I don't think the court will award aggravated damages. All right, review diagnosis. Again, this is the case of the cataract treatment when the patient was not responding to steroids. Here, the court said the fact that the doctor did not review the diagnosis, that was enough to show that aggravated damages could be awarded. Here, the patient was not responding to treatment. And on the facts of that case, it was that the pharmacy gave the patient 2 bottles of steroids. But the doctor was not able to say she had told the patient that you will only take it for a certain period of time and stop it. All right. So here is a little bit of communication error, which I think is very difficult knowing how hospitals operate, because the doctor, if you have clearly told a patient something which is important, please document it. All right. And I think that pharmacies also must work together with the doctors for certain types of medication. If it's not necessary, you just give them the minimum. And then if there's a need for it to be increased or to be re-prescribed, the patient has to go and visit the doctor again, and a fresh prescription list to be given to the patient, and the pharmacy dispenses the medicine. I don't know how we can avoid it, but we'll have to think about it. All right, and the final one, of course, no delays in treatment is the same thing that I stated earlier. So I think these are the main areas that I have covered on the topic of aggravated damages and punitive damages. And I hope that you understand a little bit more about the recent developments in aggravated and punitive damages. Thank you.
So thank you, Shamini, for the excellent lecture. So just want to remind you all again about the comments. So if you go to the YouTube app, and if you're not already watching this in the YouTube app, you go to the app by tapping on the title at the top of the video screen if you're on the DOPS Medical Legal CME page. So the video you tap, it will take you to the YouTube app or the YouTube page, and then you can see the live chat. There's only one comment there. What happened to the video? So I apologize for the 2-3 minute loss of video. That's because Unify failed us and died. Then we had to reset the router. So many apologies once again. So if there are questions, I'm going to have to bring Miss Shamini aboard. Uh, and I'm going to add her on screen. Um, Greetings, Shamini. Thank you for joining us.
Yes, good evening, Alan. I'm happy to be on board.
Yeah, it was a wonderful talk. Spoiled a little bit by me in the middle when the stream died, but we managed to restart it. Again, it's a very important topic on aggravated and exemplary damages, and this is an update with even the very latest cases, even up to last month. And I like the way you ended the talk with by actually prevention, because prevention is indeed the best policy. Of all the things you mentioned in prevention, which you think is the most important? Is it documentation, the communication, or what do you think? If you have to prioritize it, so to help the doctors know what.
I think, of course, the most important is communication, because I feel that even before a claim is brought, the claim is usually brought because of failure of communication. Because when there is a complication, a lot of times people panic, and between the medical legal implications, there is a certain amount of not facing the patient or the family, and that I think leads to a lot of unhappiness on the part of the patient and family, and it leads to a claim being brought. So I think the most important is the human element, which is communication. Never hide from the patient. If I think it starts before the procedure, that you must have good lines of communication, that you tell the patients of any possible complications which may arise, so that the patient has informed consent, because I think that again is another area which is very important. So if the patient has been informed of the risks and of the procedure, then the second part of it, it must be documented. You cannot just rely on the consent form. Somewhere in the notes, in the clinical notes, it must be documented. So it starts off with communication, I believe. That's the most important. And closely aligned to communication is, of course, the medical records, is the keeping of proper medical records. A lot of problems occur because I think either there's retrospective reporting, or it has been shoddy reporting, and then later on, it's revisited, and then you start to what the court feels that you are covering up, but actually perhaps it's not. It's just retrospective reporting. So that part of it, so long as you document the time and you initial it, and it matches all the other graphs and timing, then I think that's fine. So these are the two main areas: communication and records. I think this is the most important.
Yeah. So thank you. Very important reminder. I have also There have been no questions so far in the chat. I hope people know how to get to the YouTube chat, other than to complain that the video was interrupted. But you mentioned, a lot of it is up to the judge. We also mentioned at the beginning, when they make the case, they must mention they also want aggravated damages, if
That's
I'm not
true.
mistaken.
Yes.
But if they didn't, can the judge arbitrarily award as well? That was not very clear to me.
I think now it is clear that They can't. If they don't put it, because there's a federal court decision which clearly says it must be pleaded, which means it must be in the document. Previous to this federal court case, aggravated damages was treated as part of general damages. So the earlier cases, I think they did not differentiate between general damages and aggravated damages. And in those cases, I believe even in the Dr. Hari Krishnan case, there wasn't a specific prayer for aggravated damages. But it is a species of general damages, and the court awarded it, even though it was not specifically pleaded. But now, what has happened is, I think the law has become, rather, the courts have become, they've decided it has to be fair to the doctors and the hospitals. So they say that if you are claiming for it, it must be specifically pleaded. Now it has to be pleaded in the document, the statement of claim.
So if say they win the patient wins the case, but can they appeal for aggravated damages after that if they felt, or is
Yeah.
that's the end?
No, no, no. They can. You see, what happens in the appeal process is to say that the judge made a mistake on the law and on the evidence. So if they feel they've been wrongly denied of their right to aggravated damages, they can appeal. But it's harder on appeal, I think, to be awarded aggravated damages. Usually the appellate court leaves it to the trial judge to decide whether the conduct was acceptable or not acceptable.
Okay, thank you for the clarification. Well, we actually exceeded time. It's actually 9 o'clock already, 9:04 to be precise. So this is the moment you all waited for. If there are no questions, just a reminder again, please subscribe to our channel so you'll be notified of our upcoming live sessions. So this is the QR code. I'm sorry, you cannot, if you're watching on the phone, you cannot scan the code with the same device. You actually need two devices. So if you have, you're watching this on the laptop or a tablet like an iPad, you can use your phone where the MMA app is installed. Launch the MMA app and then you scan the QR code and get the point. I just tested it and it works. But bear in mind that the code will be valid only for about an hour. So by about 10 o'clock or so, I think it would not be valid anymore. You can't get your point. Okay. Mm. There's one comment from a doctor. Nowadays, many clinics use software. I presume that means electronic medical records. Do you have any comments, Ms. Shamini, about how this would matter as far as aggravated damages concerned?
I think this is where security becomes very important, because I think the problem with the software is it's easier to detect if there's been any addition or deletion from what I can see. So I think that you've got to be very, very careful to use the software at at the relevant time that the entries are accurate. The problem I think with the software is, again, because there's an emergency or something happening, we find that you're not updating your entries in the software. You have to be more careful. I think with software it's harder, isn't it?
Yeah, I think it's just like you cannot alter electronic medical records now. So there's
Yes,
also an
exactly.
audit trail, so you cannot change it. And in anyway, you shouldn't be changing it. You can add on comments or records, but you cannot change your original entry. Yeah. If you can change it, then it's not a proper electronic medical record, I think.
I think the
Okay,
way
that's
it's
a
being done is
yeah,
from what I've seen, is the doctors, if they want to add anything which they feel is material, they put an addendum into the
yes.
original
Mm,
record.
yeah.
So just be careful
Um,
with whatever addendums you're putting in.
mm. So does Dr. Fu has a comment and question. So we are open to a slew of claims, general, special, aggravated, exemplary, punitive. Has anybody been successful with appeals?
I think to be fair, the recent cases that I've mentioned, the appeals are pending. So we hope that they will be successful. As far as I know, either that the appeals are pending. The cases I've been speaking about, where they've been awarded, they're all pending appeal at the moment. It's not been heard
Okay.
yet.
All right. So we'll watch this space.
Yes.
There's a question about this Good Samaritan, Bad Samaritan hypothetical scenario. The doctor did not come forward to help somebody in a public area and then receive a letter of demand. Will Dr. Shield provide free legal service?
I think this is directed to Dr. Shield, not to me. I cannot answer this question.
Yeah. Ms. Shami is just here to give the legal point. Maybe you join the Docs Forum and then we will guide you to the Dr. Shield as a Telegram group and you can actually post your queries to Dr. Shield there. Okay. Dr. Yu has a question. Would you advocate not holding an internal inquiry as a way to avoid self-discriminating facts from the pre-court discovery request? Interesting question. So is the internal inquiry detrimental to the whole process now if, as claims can go up to damaging, aggravating, or aggravating damages and all that? If internal inquiry may not help, may actually make things worse. What are your
Actually,
comments?
I don't agree with that because I think the most
Mm,
important thing is patient safety. So I believe that the whole process, which is endorsed, I believe, by the Ministry of Health, as well as every risk management program that every hospital has, the main reason why we're holding the internal inquiry is actually to improve patient safety. So it is actually wrong to say you shouldn't have the internal inquiry report because it may open you up to disclosing this internal inquiry report to the patient. But a lot of there have been a lot of ways in which you may be able to protect this report from being released to the patient. One of it is if you get a lawyer to sit into the internal inquiry, then you could say it's protected by solicitor-client privilege, and therefore this document need not be released to the patient. However, this has received a lot of resistance, I believe, from many hospitals and clinics because I think they would like to deal with it on an internal basis and they feel that even a lawyer being there is a third party. All right. But I think what my advice to all medical practitioners and hospitals is that if there is an incident you think might lead to a potential claim, the most important thing is to notify your insurers. All right, so you must say that this is a potential claim so that if the claim is brought by the patient, you are covered. All right, so the most important thing is not deciding not to have the internal inquiry, but rather notify your insurers that it may be a possible claim.
okay. Very, very important points. So let me see if there are other questions. I think that's about it, Shamini. So I think if we're 10 minutes past our time, and I'd like to thank you once again for excellent presentation and your um, insightful answers to the comments posted. If you're watching this late and the CPD points does not work anymore. So you head over to the Dr. Shield Medical Legal CME page, which is dops.my/medical legal dash CME. And then at the bottom of the video, which you can watch even when the live stream is over, and then when you want to claim the points, there's a link to the CME module. Okay, just click on it. It will take you to our bulletin board and then log in and you'll be a CME module. There will be a link there. You can click and then do the MCQs, which are from Ms. Shamini. Not very difficult, but you need to get all of them right. Okay, so head over to our webpage. Okay, All right. So I wish everyone good night. Wait a minute. I will don't want to take Miss Shamini's time, but I will stay on a little bit more because there's some question related to CBD points. I'll just answer them before we cut off the live stream. So anyway, good night, Shamini, and I'll see you again in your next talk. We look forward. Okay. All
Good
right.
night, Alan.
Thank
Thank you
you.
so
Yeah.
much for
Good night.
having me.
Yeah.
Good night.
Thank you very much for your excellent talk. Okay.
Thank you again.
All right. We thank Ms. Shamini, and there are some questions actually from the dental side. I think because our dental colleagues have also joined the webinar, and I am not sure about your question. Is if you're not an MMA member, how else can we scan a QR code for CBD? I wasn't aware that the dental colleagues would be also getting CBD because the MMA is a CBD collector. That means we apply to the MMA for CBD points, and actually the points only assigned to medical doctors. So I'm not sure of the mechanism for dental doctors. I think I'm not sure how you claim points, and the because everything goes through the for doctors, and then it's submitted to the MMC, not the Dental Council. It's something we'll have to investigate. So I'm sorry, we don't have a pathway for you to scan QR codes for dental CPD. My apologies. Okay, so I hope you all can um, get your point. Have anybody failed to get QR code scan? Those of you who are medical doctors, because the MMA app can be used by MMA as well as non-MMA members, but it goes only to the MMC. So it's the Malaysian Medical Council, not the Dental Council, I'm afraid. But nevertheless, I think it's been a very educational talk. I hope we all learned something about aggravated and exemplary damages and how to reduce the chances of all these things facing us in our practice. So without, I think we have to stop now. I There will be the aim is to have the medical legal series every month on the second Wednesday. So our next session for medical legal will be in on May on the second Wednesday. But look out for the announcements in our forums, and also if you subscribe to our YouTube channel and hit the notification bell every time we schedule a live event, you will be notified so you won't miss it. Okay. All right. So Suresh has said there is no MDA app. Dentists can download the MMA web, register there, did it, and got the CBD point. Download the MMA app, I think, register and get the CBD point. I'm not sure what's the pathway for dentists and how they get the point uh, registered to the Dental Council, because the points from the MMA app will go to the Malaysian Medical Council when you renew your APC. So I'm not sure whether it goes to the dental one or not. Okay, so we have to clarify that. Okay. Yeah, so it's the MMA app. All right. Thank you, Dr. Suresh. So I'm going to end the broadcast now. So I wish everybody good night and have a great rest of the week. And if you are still interested in more CBD, join us on the SJMC Grand Rounds this Saturday. The link is also in our dops.my webpage. If you go to the menu, you'll see the SJMC um, grand rounds coming up. Okay, and it will be on syncope. Is it always an arrhythmic cause? And we have our esteemed panel, Dr. Kanan, Dr. Shirini, and Dr. Yap. So just a little bit of advert for the SGMC cardiology team. So anyway, wish you all a great week ahead, and have a good night.